DC. We have anyone present on that matter?
Nathan Ballmer here.
Thank you. All right, do we have Ms. Short present? It does not appear that Ms. Short is present. I would ask the individual labeled as Zoom user, they could unmute and identify themselves for the record.
If I'm Zoom user, I'm Rihanna Granger.
All right, thank you, ma'am.
Yes.
All right, you can mute. Thank you. All right, we're here for a cause against Mr. Ballmer. Ms. Short is not present. As the notice indicates, if the complaining party fails to appear, the contempt proceeding may be dismissed. Given her failure to appear, I will dismiss the show cause. Any questions, Mr. Ballmer?
What do I have to do to file more paperwork on my end to get a court date? Because this is the problem I'm having as well. Just no communication, and she's here again, gone again. I just was wondering what I could do to get my ducks in a row.
Sure. You can, there's packets here that you can get from the front of the court that you can fill out. The motion you want to file, if it's parenting time, custody, support, or whatever you want to do, they can certainly help you with that paperwork.
Okay, sounds good. Thank you, sir. Hey, I got another quick question. I got another question for you. Sorry. How late are you guys open up there?
4:30.
Okay, thank you guys. I appreciate it, and that's it for me, I guess.
All right, you're all set.
Thanks, sir.
19590UN. Do you have anyone present on that matter?
Kristen's here.
Thank you. Does not appear that Mr. Seidel is present. In front of the court, what is the status of this matter?
This matter was adjourned from November 20th to monitor the defendant's payments made. You would ask that he pay $800 before today's hearing, and it could be canceled. However, no payments have been received. Support obligation is $400 a month. Current balance is $12,648.50. The only payment we received was in September of 24, which was the STIP payment to dismiss a bench warrant. I did speak with him on the 11th. He advised that he was seeing some progress with this case in Florida, but also indicated that they were coming after him for support as well. He agreed to provide paperwork, and the paperwork that we received yesterday indicated that they're in mediation, but nothing as far as the support.
Thank you. Ms. Seidel, anything that you'd like to say or any questions that you have?
Yeah, so the Florida thing, we have not gone to mediation. The mediation specialist and I just came together and got a date because Thomas refuses to communicate with myself or her when it comes to that. There's been no mediation as of yet, and he's court ordered in Florida to pay me $80 a month, fails to do that, and he has failed on multiple occasions to work with my lawyer with a new parenting plan with our youngest son. He refuses to communicate with me. I'm trying to resolve this, but it's talking to a wall, unfortunately.
Does he exercise any parenting time?
He has. Cooper is in Michigan, and that's why I've been trying forever to get this new parenting plan, and he refuses to do anything as far as progressing that.
All right. How long has he been in Michigan?
Cooper's been in Michigan for a year, and I've been trying to deal with this for a year. So my only issue with Tom is that he has back child support from Florida that he's not taking care of, and he refuses to do anything about that.
Well, certainly the amount owed has been accumulated over the years.
Yes, sir.
So for the court, he was aware of this hearing?
Oh, yes.
Okay. All right. Well, I mean, given his failure to appear, notice was sent to him to appear on today's date. He's also been in contact with his caseworker. Given his failure to appear, I am going to recommend the bench warrant, amount of $3,200 plus $100 in costs. Any questions, ma'am?
No, just want to resolve this, but thank you for everything you guys are doing.
All right. Thank you. You're all set and can sign off.
All right. Bye-bye.
694 DC. Do you have anyone present on that matter?
Rihanna Granger is present.
Thank you. And this is a motion in show cause regarding attendance of the SMILE program. As to Ms. Granger. Ms. Granger, have you attended that program yet or made arrangements to attend it?
No, sir. I wasn't aware that I was supposed to attend it until I had to make this call. Do I make the appointment to do the class with you or through the friend of the court?
Front of the court will have a list of dates and times that it's available, so you can contact them.
Okay.
Are there some upcoming dates that it's available?
I'm available. Sorry.
I'm just asking the front of the court.
6th.
Pardon?
I think the next one's on the 6th,
Okay.
January 6th.
January, okay. Is there more than one a month now or not? Only one. Okay. So it happens once a month. There is one on January 6th that you can do.
Okay. Do I just do that over?
Yes, that is over Zoom, correct? Yes.
Okay.
So
Perfect.
contact the front of the court about signing up for that. I'm going to adjourn this matter. Well, I'll have front of the court issue a date that works with their calendar. So I'm going to adjourn you out to either January or February just to make sure that you get that done. Okay?
Yes, sir. Thank you
If you
so
don't
much.
get it done, if you don't get it done, then your case cannot be closed ultimately, and you could also be found in contempt and be sanctioned. Okay?
Okay. Thank you, sir.
All right. So make sure you contact them, get that information, and get signed up. Thank you.
Well.
33 EM. Do we have anyone present on that matter?
I'm here, Your Honor.
All right, Mr. Stahl is present. This is a show cause against Mr. Stahl. The order for today indicates that if the complaining party fails to appear, the contempt proceeding may be dismissed. Ms. Keene is not present. Given her failure to be present, I will dismiss the show cause. Any questions, Mr. Stahl?
I do have one question, Your Honor. It seems like on our page 4, paragraph 6, it's just been a stickler wheel with her. That's why I'm in court here constantly. And what she's coming back at is in that paragraph, it says, and I'm just going to read it right here. If the parent's work or school schedule requires the children to go to daycare or a grandparent's home, then the other parent will be notified and has the right to have the children before the children attend either daycare or the grandparent's home. He's 18 now, so he's graduated out. Gabby's 16 and working on her driver's license, and she just had a job at Spirit Halloween this last year for just a month, but they liked her so much that they wanted to start working again in July when they start setup, and they said next year they're going to go from Spirit Halloween to Spirit Christmas, and so basically she'll have a job from like mid-July till the end of the year next year. And being 16, and then obviously next October she'll be 17. I don't think we need this paragraph anymore, so I'm going to ask if we can get rid of that paragraph.
All right. Well, to change something in your judgment, you have to file a motion to seek that. Okay.
Okay, I thought that's what this kind of was for, but okay, maybe not. Okay, well, maybe I'll file it.
Against you. If she was present,
Okay.
we might be able to address it, but if you think that provision should be removed, you can file a motion to do so.
Okay, I will do that. Thank you so much.
All right. Thank you. You're all set.
Okay, thank you.
06 DM. Do we have either party on that matter present?
Yes, Your Honor, Stephen McClure.
All right. Good morning, sir. We're here today for a show cause filed against you for failure to attend the SMILE program, which was ordered back in May. Have you attended that program yet, sir?
No, sir.
Have you made any arrangements to attend a session?
Not yet, sir.
All right. I know there's one next month. I think January 6th is the date. It
Perfect.
is done by Zoom. You were previously ordered to attend that. I will give you one more shot to attend it before addressing potential contempt. So we're going to adjourn your case to sometime later in either January or February to give you time to attend that. You can contact the friend of the court to get more information on what you need to do, but you need to get signed up and go to that class. Okay, sir?
Yes, sir. Thank you very much.
All right, I think you've got another matter here later, but it's not until
9:45.
9:45.
Yep.
Yes, okay, all right, thank you.
Thank you.
16137DS. Ms. McCarrick is present. Mr. Huntley, if you could please unmute, let me know if you can hear me okay.
Yes, sir. I can hear you okay.
All right, and this is your objection regarding a child support recommendation, is that correct?
Yes, sir.
And what is the basis of your objection?
Well, I guess my basis of objection would be that I guess the amount wouldn't be sufficient because that's not even one paycheck for me.
All right, so you think it should be adjusted higher or lower?
Lower.
Okay. Are you working full time, sir?
Yes, sir. I actually established, well, I'm not a full-time employee at Federal Broach right now. I am employed through People Link Staffing. I started this job July 15th of this year, and I will become a full-time employee January 6th.
All right. Will your pay change when that happens, or it will stay the same?
It will actually, well, with the cost of living this next year, I was told by the owner or the president of the company that with the economy or the boost next year, I will end up getting a little bit of a pay raise.
All right. Did you provide your financial information to the front of the court so they could do the support review or not?
No, sir, I didn't.
All right. So front of the court, how was his income calculated?
It was computed utilizing Michigan quarterly wages reported for the third quarter of 2024.
So, sir, I'll give you a shot then. If you think you can you submit some pay stubs and show what you've been making there?
Yes, sir. Your Honor, is there any way that I can get like a fax number to be able to send my stubs to you guys?
Sure.
That
989.
Are you ready to write it down, sir?
Yes, sir.
989.
Yes, sir. All right, so you need to submit copies of your pay stubs so we can get an accurate figure as to your income. Ms. McCarrick, anything that you would like to say or any questions that you have?
Nope.
All right, so I will grant the objection. I will indicate that Mr. Huntley is to submit additional financial information. You should submit that within 14 days, and then a new recommendation will be prepared.
Yes, sir, Your Honor.
All right, thank you both for appearing. You are all set and can sign off.
Thank you.
Thank you.
DM. Mr. Jarvie, can you hear me okay?
Yes, I can, Your Honor.
All right. I see that Ms. Aber is signed in also. Okay, she is present also. And Mr. Jarvie, this is your objection to a child support recommendation, is that correct?
Yes, sir.
All right, and what would you like to say regarding that, sir?
Last July, I retired from teaching and started receiving pension checks from the state. My monthly pension check is $2,052 a month. That's after deductions and a $576 payment to Miss Aber. After I receive my check of $2,052, I have a mortgage payment of $953, which is my house payment, insurance, and taxes altogether. If I have to pay the recommended $925 in child support, I will be left with approximately $173 to pay my bills and take care of our daughters when they're with me during the year. So I'm asking the court to consider reducing the child support of $925 so that I can have enough money to live and also pay my bills and take care of our girls.
All right, was there anything in the support calculation that you feel was inaccurate?
On my end, no.
Okay. Ms. Aber, anything you wish to say regarding Mr. Jarvie's objection?
I lost my job through no fault of my own in April of 2022. I looked for a new job through the summer while I took care of our kids, and then I filed for a change in child support and was denied. My plan was to seek new certification to get a new job, and they said that wasn't okay. I had to have a new job before I could make a change. So I got 2 jobs, and I refiled, and I was still denied and said I had to get support based upon the amount of $38,000 of salary that I made only when I had a COVID bonus. My actual salary was between 27 and 30,000 a year. So that was denied again. He chose to retire and he was instantly granted a change. And it's not based on what he's capable of earning. It's based on what he's actually earning. Right now, he's only making $600 a month working full-time at the school. And I believe that based on the salary that he said he was making per year before, which was in the papers he gave us in the summer, was $87,973 at the school, plus whatever he made playing his instrument, another $2,500 plus what he makes making lessons. I believe he can get another job that pays him more than $600 working full-time a month, which he's working at the school right now where he used to teach, but that's what he's saying he's making there, working every day. So I would just like him to be held to the same standard as me, and get another job to pay for it, which is what I had to do to take care of the kids when I lost my job and couldn't get the child support changed.
All right, thank you. So the court has heard from both parties. This is Mr. Jarvie's objection, indicating that with the amount the support is calculated, it caused him some difficulty with other expenses. However, the court is required to consider all income that the parties receive. In making the calculation, there is no argument or showing that the calculation itself is incorrect based on the numbers that the front of the court has used to make the calculation. It does appear that the amount from the pension that both parties receive was used in the calculation. So the portion that Ms. Aber receives was used as income for her. The portion that Mr. Jarvie receives was used as income for him. And then there was some additional gross income from each party. Given that the objection does not satisfy the showing that there is any issue with the way the calculation was made and the numbers used, I will deny the objection. All right, you do have the right to file an objection to what I just did within 21 days. That information will be provided in the matter be heard before the judge. That information will be provided in the documents that are sent to you. All right, thank you both for appearing. You are all set.
Thank you.
Thank you.
All right, looks like we have Miss Rosen present and Mr. Marlott. Can you hear me okay?
I can hear you. Yep.
All right, thank you. Sir, this is your objection to a child support recommendation. Is that correct?
Correct.
All right, and what are your objections?
Well, in the first hearing, I had no knowledge of friend of the court or how it worked, so I just kind of didn't argue anything at that first hearing, not knowing what the consequences could be. So on a typical week, he goes to school in Gaylord. I live in Atlanta. On a typical week, I have him Friday, Saturday, Sunday. It was presented in the previous hearing that Amy has him 2/3 of the time, which would be 66%, but 3 days out of 7 is 57%. Our agreement when we divorced was always 50-50 custody, 50-50 time with him. Because she moved him to school in Gaylord, of course, that makes it difficult for me. So in order to make up for time lost during the school year, he's supposed to be at my house more in summer. So that's how we deal with trying to make it a 50-50 time split. So
All right.
the 2/3 is incorrect, basically.
So you have you have 3 days every week during the school year?
Yes, I might add, I drive 180 miles because I have to make 3 trips to Gaylord. He usually has a practice of some sort, whether it's baseball, basketball, one of the days.
Okay. And how was this last summer handled as far as parenting time?
Well, it was made a little bit difficult by Amy because when he wasn't having a practice or something, it seemed like something would always come up, like the school was offering a weightlifting class 3 days a week. So he goes there for like 20 minutes, and kind of like she was requiring me to drive him over there for a 20-30 minute
So my
workout.
question was, how many overnights do you think you got last summer?
Well, whenever it worked out, he was at my house more during the week. Yes.
I don't know what that is. So how many nights, how often do you think he was at your house over the summer?
Well, usually 2 or 3 weeks. So that'd be, well, actually a little more. It'd probably be closer to 4 during the summer. There were weekends where he would have a baseball tournament or something, and she always took him to those. But I think you could safely say, so 3-4 times a month, 12. Well, if we're calling the summer June, July, August, I would say like 45 to 50 days.
All right. Ms. Rosen, what are your thoughts on what the schedule looks like as far as overnights?
So of the 365 days in the year, and forecasting the remainder of this year, which we have a couple weeks left, Bob has had and will get to 120 overnights of the 365. As far as the summer, June, July, and August, in June, he had him overnight 3 times. In July, he had him overnight 16. And then in August, he had him overnight 12.
What's currently happening on a weekly schedule? He indicates he has 3 overnights a week during the school year. Is that what you guys are doing?
So what changes are Donald's athletics. And so when he has weekend tournaments, whether it be basketball or baseball, I have been the parent that is taking him to the tournaments and handling those arrangements. So that affects the weekends. For October and November, I would say pretty consistently, because he didn't have any weekend events, he was at Bob's the 3 nights that Bob mentioned. But it changes a lot. January of last year, Bob had him 5 overnights. January and February, Donald will probably have tournaments every weekend. And so that's where things get affected. I have the numbers for the full year if you want me to run through them.
Well, you indicate that it's about at 120 for this year. Is that correct?
That's correct.
Okay. All right. Mr. Marlott, anything else you wish to say as far as the overnights are concerned?
Well, I do. These tournaments she mentions, I'm never given a schedule, offered to take him myself. This is where we run into trouble. She just takes him, and then, she has no problem infringing on what I would consider my time. So moving forward, I'm going to make sure it's 50%. And if it isn't, then we will take some action on that.
What does your custody agreement say, if you know, sir?
50-50, everything.
Well, what does your parenting time arrangement say?
Everything was 50-50 when we divorced.
All right. So I'm looking at a judgment of divorce. Have you guys ever altered the terms as far as the judgment of divorce when it comes to custody?
No.
All right, so I do see, I guess in that, it indicated pairing time is as the parties agree. And then back here, looks like in September, we also indicated that pairing time is as the parties agree. So the difficulty when that's the language is there's nothing specific, which is kind of why we discussed going with that 2/3 last time we were here, as far as the overnights were concerned. You know, the
Right.
judgment itself doesn't say, it says you gotta have joint custody, but joint custody doesn't always mean necessarily 100% 50-50 as far as overnights. It did indicate on the judgment to go with 182.5, but then we altered that in September. So when there's not a specific schedule, you know, the court has to look at what is the calculation of what has been going on. And it does sound like Ms. Rosen has kept some records on what has been going on. And I know when we were here before, we kind of went with that figure.
Well, I'm not sure how she came up with her records, but I have kept a record. Well, since I realized we were going to do this, I have the last 3 months. And it backs up what I'm saying, that I have him more than the 2/3. It actually ends up being, you know, if you just kind of went with the 3 days out of 7, it kind of averages out that's what it is on my schedule. That is from when we started this in September through the end of the year, based on what has been planned for the holiday.
And then
And
she
the
had said
other,
that for summer you had about 31 overnights. You thought about 45. Did you have anything that shows the number of overnights you had in the summer?
I don't have anything written down. I wasn't planning on doing this, so I really only started from the time when we started this proceeding. So if she's making stuff up previous to that, I can't speak to that. But
And then as to the issue, what would you like to say on that?
which issue?
The income, you also objected based on an income issue, is that correct?
Yeah, I do object to that because I know that she has had a job at a restaurant in Boyne City within the past 3 years, which they took my income and basically divided it by 3 over those 3 years. And what I was told by the FOC lady, or the caseworker, I guess you'd call her, she said that it was her understanding that Amy had quit the job, and so that they didn't include that income in her numbers because they wanted it to be accurate. Well, I was a sole proprietor in my business, and now I'm an LLC acting as an S corp, so I receive a paycheck weekly. So there's no debating what I'm bringing home per week. And if you were to just take my numbers, I don't know if you have that sheet. I put the numbers on there. So it seemed like gross income is what they were wanting to look at. She came up with 8520.37 for my gross, but my weekly is 1762.11, which if you were to divide that out, a normal 4-week 4-pay month, it turns out to be 7,048. Or if you were to average the whole year, you're about 76. So it's about $1,000 difference from what she was calculating. Which,
when did you make that change in your employment?
October 1st was the start of it.
All right. Do you receive any other benefits other than the weekly paycheck?
No, that's my income right there.
So if the company makes a profit, that's not your company?
It is my company, yes.
All right. So if there's a profit, do you then get some other benefit at the end of the year, or where does any profit go?
Well, for now, it goes into the business. It's relatively new, so I'm not sure how all that will be handled in the future.
Okay.
I also have something I didn't find out about until Saturday was the insurance calculation, which is also incorrect.
All right. What's incorrect about the insurance calculation?
Well, I was looking into getting, because I haven't even had health insurance the last couple of years. So I was looking into getting my own policy, which I did, and I was just in conversation with the insurance agent. I told her about this situation where they want me to pay 65% of Donald's health care. So I gave her the number. They listed $982 as their monthly, what they pay per month. And then when they calculated Donald's portion of it, they just divided it by 3, which came out to $327, and then took 65% of that, which is $213. And the insurance agent said, no way that you could insure, that it costs the same to insure a 13-year-old kid who's healthy, the same rate at, 50-year-old adults. So I don't believe that's accurate. However, she told me she took it off of the taxes. I don't know what she looked at, but what I would like to propose is I would like to just put him on my policy, and I'll pay for all of his health insurance.
All right. Anything else you'd like to say?
Only that, again, I would make that offer just to pay for all of his health insurance, and they wouldn't have to contribute anything. The only caveat is I have to claim him on my taxes, and I would be willing to split the child care credit with Amy. That would be no problem. Typically, we've been alternating years that we claim him. Like this coming tax season, she will be claiming him. So next year is my year to claim him. But moving forward, if I can just put him on my insurance policy and claim him on my taxes, I'm happy to split whatever the child care. I think it's about $2,000. So I would split that with her.
Ms. Rosen?
Yeah, first I'd like to go back to the overnights. Bob is painting me in a picture as if I'm dictating Donald's extra. Pardon?
We don't need to go back to the overnights. So I give you both a chance to make your arguments there. So let's go to the income issue. He indicated that you have some income that was not included. What would you like to say regarding that?
Yeah, I'm not employed at by Magnum Hospitality or Cafe Sante. I haven't been for approximately 7 months, and I work full time at Bliss Salon and Spa 5 to 6 days a week. When I started at Bliss, I did take that job because I didn't have. I did take the Cafe Sante job in order to help supplement my income. I'm now full time at Bliss, and so it just didn't make sense for me to continue driving to Boyne. So I don't work there.
Okay. And then as to healthcare, what would you like to say regarding that?
I think it's a bigger conversation. I would like to know what type of insurance that he's proposing, what the policy entails, what the deductible is, what the copays are, all those things. We've carried health insurance on Donald for 5 years. And so, it's just a surprise to me that here today, Bob wants to now carry health insurance on Donald. Also
Okay.
we dental on Donald. So I'm curious if Bob is proposing dental as well. I did submit all the documents with regard to our health insurance to friend of the court. And so they have all the numbers.
Do you know if that breaks down individually what each's premium is, or is it just shows what the total is for all the people on the policy?
I'm sure that it breaks down individually. I would have to get that breakdown.
Okay. Friend of the court, anything you'd like to say regarding these matters?
Just that we had taken the information about insurance directly from her tax information she provided to us.
Okay.
That is included in the folder up there, so I do feel that it is probably accurate.
You think it costs the same to insure a 13-year-old kid as a 50-year-old adult?
All right, so I'm not sure where your question is directed, but we'll take a look at to see if we have a breakdown that is separate. I'll let front of the court do that after we are done with the hearing. All right, anything else you want to say, sir?
Just on the insurance thing again, like, I'm not sure why she would worry about, like, what I'm offering is to pay for all of it. I'm not asking her to pay 35% or any of it. So I don't really know what it matters what the copay is, because that would be my responsibility.
All right, so heard from both parties on the objection. The first is the overnights. I am going to deny a change in overnights. We were at a prior hearing where there was discussion to go with about 2/3. Testimony from Mr. Marlott is recently he's been getting typically 3 overnights a week during the school year. But there have been weekends where he doesn't get his overnights and mom takes the child to some type of events. The summer, really, I find Mr. Marlott's testimony more of a guess in his bag as to how many overnights he actually had in the summer. Ms. Rosen indicated she had kept track, and he was on pace for that 120, which we had calculated previously. So without additional proof, I am going to deny the objection as to the overnights and keep the overnights at the calculated 120.5. Again, as indicated, when the order simply says parenting time as the parties agree, then it does make it more difficult to get overnights. The party has a right to seek a specific parenting time schedule, which then makes the overnight calculation certainly much easier. As to the income, based on the statements of Ms. Rosen of not working that job anymore and maintaining full-time employment, I would not add that to her support amount. Mr. Marlott has indicated he has changed the way the business is operated now, changing from a sole proprietor to an LLC operating as an S Corp, and he's getting a paycheck. This is a new arrangement, and certainly there are potential other income that could be calculated if that is his corporation, which it appears it is. So there may be other benefits received, and that is a new corporation. So as he indicated, he's not sure ultimately what all those tax benefits and revenue are going to look like, as he has not gone through that cycle yet with the new way the business is organized. So given that that is a new matter with some inconsistency at this point, I would also deny the objection as to the income issue. I think after next year, with a full year acting as the S Corp and the LLC, we would have a very clear picture of what his income looked like for in the year of 2025. And if there is a change, he would certainly be eligible at that time to file a motion for a support review if the new structure of the company shows a change in his income that was calculated for this particular review. As to the insurance, I will have friend of the court review their file and see if they can get a breakdown of the specific premium for the child in this case. And if it's not there in the paperwork that's already there, then I would indicate that Ms. Rosen needs to provide that information to the court upon the caseworker notifying her that it's not in the paperwork that they already have. And then we can do a new calculation based on that change in insurance if there is a change. As far as future insurance, and I can't make a decision or today, and I don't think I could put Ms. Rosen on the spot, but certainly it would make sense for the parties to have that discussion and for Mr. Marlott to present to her what the co-pays and premiums and everything looks like for whatever policy he's able to have. And then hopefully if that is a better policy, the parties would make a sensible decision and change that. And if that change happened, we would also put that into a different calculation. The parties do have the right to file an objection to my recommended decision within 21 days. The matter would be heard before the judge, but we will look at making those particular changes. Any questions from front of the court?
No, sir.
All right.
Oh, can I ask a question before we dismiss?
Sure.
I'm just at this point that the request was made in July and then we had our first hearing in September. At what point is there any type of, like, he has any obligation to provide some support as I'm managing all?
Provided you some in September.
All right, so I'm going to cut you both off because I'm not going to have everybody arguing back and forth. I've made my recommendation. There is an effective date on the child support calculation, but it is not an official order at this particular moment. It will be, looks like it does get backdated. An effective date of September 18th. I'm not sure what was in place before then. But once it goes into place, if he doesn't have credit, he'll have a very large arrears to deal with. But unfortunately, with objections, we do run into this process where things get delayed before becoming a final order. All right, thank you both for appearing. You're free to sign off. 06 PM. We have parties on that matter present.
Steve McClure is present.
Thank you. All right, I'm just having the court grab that file because when my case was called before, I then put it in my to-go stack, and that stack left the court. Thank you. All right, we're here today on a objection to a child support review. This was filed by Emma McClure. Ms. McClure is not present. This matter was set for 9:45. It is now 10:10. So it was 25 minutes after it was scheduled. Given her failure to appear, I will deny the objection. Any
Thank
questions,
you.
Mr. McClure?
No, thank you very much.
All right, you're all set. Thank you.
I appreciate your time.
157. Thank you for being here. P.S. We have the parties on that matter present.
Yes, sir.
All right, we have Ms. Ormsby present. See another individual listed as Kenneth. Sir, are you Mr. Engelhardt?
Yes, sir.
All right, this is the party's motion to opt out of friend of the court services. Is that correct?
Yes.
All right, I do see you have filed paperwork. My understanding is there was public assistance. There no longer is public assistance. Is that correct?
Yes.
All right. I do understand that there were also confinement expenses that were ordered at one point, and those are not paid off. Is that correct?
I'm not sure what that means.
All right. So there was an order of birthing expenses at one point that were ordered to be paid as part of support. Is it correct that amount is still outstanding in front of the court?
Yes.
Okay. And is there in arrears in this matter?
There is, and I'd like to waive that.
You'd like to waive that? Okay. All right, so as far as completely opting out, there are some policy changes coming into effect, which might have an impact on the ability to opt out. But we need to adjourn this matter to address that issue, to wait for those potential changes. So I'm not going to make a decision today. I'm going to adjourn the matter to after January 1st. We will send you a new date. We need to address some of those changes regarding the support guidelines. Mr. Engelhardt, are you paying support right now through an income withholding order, or do you pay it a different way?
It comes out of my check.
All right. So we can place a hold on that being distributed at this point. Is that correct? All right. So we're going to place a hold on the support pending the adjournment and a final decision. I'm certainly doing that because Ms. Ormsby, you've indicated that you are willing to waive the arrears. Is that correct?
Yes.
Okay. All right. So given, as I indicated, given some potential policy changes that might impact the decision in this matter, I think it is appropriate that we adjourn until after the new year to address those changes. And then we will have you back here to address the opt-out. Any questions, Ms. Ormsby?
I don't think so.
Mr. Engelhardt, any questions?
No, I'm all good.
All right. Thank you both for appearing. We'll see you again next year. Thank you.
Thank you.
All right, if you are present on this matter, you need to unmute and identify yourself for the record.
Shannon Susie.
Thank you, sir. And this is your motion, is that correct, sir?
Yes, sir.
And what are you looking to change?
I'm looking to gain sole custody of the children due to the circumstances of their mother.
Is she exercising parenting time at this point?
No, she is not. We had a custody, not a custody case, a child support case on contempt for her a couple months ago, and I dropped all rearages, all any other support payments. I addressed that I allowed her to stay in my address, place of living, so that she could be closer to the kids. And she was there roughly about 3 weeks afterwards, and then she up and left. She doesn't contact the kids. The kids call her. She won't answer the phone. I've had to yesterday give the secretary of the Friends of the Courts her new address because she refuses to do it. She left state. She's now in Missouri.
Okay.
And
what
so
I would set the matter for a short evidentiary hearing then. I'm going to set it for a 1 hour evidentiary hearing on March 19th. Do you have any travel plans that date, or will you be in Michigan, sir?
what day is that?
March 19th.
March 19th. Actually, I believe that my current wife will be in the hospital giving birth.
Okay. So I've got March 26th available a week later, or do you think we need to go into April just to be safe?
I'd like to go into April just to be safe, Your Honor.
All right. So I would set the matter for April 16th at 11. This is a in-person hearing. How old are the kids, sir?
My oldest is 15 at the end of this year. And then I will have Kyle, who will be 13, 10, and 12.
Okay. So the court does have to do a preference interview of kids those ages. So we will also have the children be here that day, arrive about 15, 20 minutes before, so that I can conduct that preference interview. You will get a copy of this hearing notice. Okay, sir?
All righty. Thank you very much.
Thank you. You're all set. 7314 DM. If counsel could please place appearances on the record.
Good morning, Your Honor. Jennifer Dusman-Coy on behalf of Jacob Reed.
May it please the court, Robert Costner Perry on behalf of Caleb Marie Wilton Reed. We are, Your Honor, she is on the Zoom with us today, but she's at her office and I'm in mine, but we're connected.
Okay. All right. And Ms. Dusman-Coy, this is your client's motion, is that correct?
It is, Your Honor.
All right. And in general, what is he seeking?
My client is seeking parenting time with the minor child. Presently, he has not seen the child in several years. He did have some personal problems of his own, He did end up going to prison, but he has gone through probation. He is doing much better now. He is now clean. He doesn't know where actually Ms. Wooten resides, but he has not had any parenting time with the minor child for several years. Understanding that probably it's going to look something like transitional parenting time that he would have with the minor child. He just wants to have some communication with her. He wants to be able to see her now and then. So we're looking at probably something not real significant in terms of parenting time, at least to start with. But he does want to, reestablish that relationship with his daughter.
Okay, thank you. And Mr. Costin is.
Yes, thank you, Your Honor. Well, I think the first, and by the way, I haven't met counsel yet, but nice meeting you. Hopefully get to work with you again. There was an order signed, Your Honor, that I don't believe has ever been modified. And I put that in all my pleadings. And in that, his the counsel's client's parenting time was taken away from him. And that order's never been modified. So, and I said in my response, I don't really believe that this motion could be considered a request for modification of the order. So if the order doesn't get modified, I really don't think she has standing to bring this motion, with all due respect. There's lots of other things that we've attached to our exhibits that we've attached, but briefly, that's what it is. One other thing. He hasn't seen this child in 4 years or more. The child wouldn't even know who he is. So if you were to ever recommend parenting time, it would have to be supervised. And to say that he doesn't know where she lives is false, because he is in close relationship with her family and they all know where she is. Or he could have filed a motion with a friend of the court because her personal protection, because she had a PPO against him, she was able to keep her where she lives confidential. It's been there for a long time. All those should have been taken care of if they really want to try to get parenting time, with all due respect.
Is client opposed then to any sort of parenting time at this time?
I'm sorry, Your Honor?
Is your client opposed to any sort of parenting time? I just asked because if there is
yes,
an option of mediation.
She's opposed to any parenting time at this point because the child wouldn't even know who he is. It's been that long. And he was in prison and had all kinds of drug issues and everything. I wouldn't be comfortable with any of that, just saying, well, he's changed his life. And especially since that order, and it's attached to my response, has never been modified. Might be able to work something out if they want to get that temporary order from March 18th of 2020 modified. Then maybe we could talk about some supervised parenting time. But at this point, I couldn't respectfully agree, or my client wouldn't, I mean.
All right. Ms. Deuce McCoy, anything additional you would like to say?
Frankly, that I don't agree with the statements made by counsel. I understand where he's coming from, but if a party requests parenting time at any time, the court is obligated to entertain that request. The order that was entered was an ex parte order that was never served upon Mr. Reed, and then he went to prison. And so then he did not have an opportunity to respond to that order. The PPO, I have no idea about. I was unaware of that petition even being filed until I received the response from counsel. And the PPO itself may have expired. I did not see the actual PPO, just the petition. I don't know if it was ever actually entered. I didn't know of its existence until this point, so I don't believe that was filed or served upon the plaintiff either. In any case, we are simply asking for, like I said, transitional time. If it has to be supervised to start with, I understand that completely. I think that we would require an evidentiary hearing on this matter so that the court could be comfortable ordering some kind of parenting time so that we can prove that my client has changed his ways. So that's what we would be asking for. We're also not opposed to going to mediation if that's something, that would be something that is amenable to counsel and to his client. But I don't know how he feels about that. If in the absence of that, we would ask for an evidentiary hearing.
All right, thank you. So I do think setting it for an evidentiary hearing is the appropriate step. If there are any dispositive issues, we can certainly address those at the start of the evidentiary hearing. Counsel, any issues with So the next 3-hour time I have available is March 19th.
I'm sorry, could you say again, Your Honor?
March 19th.
I want to look because of one thing in March that, I'm sorry, Your Honor, if for some reason it got garbled. The date again, please?
March 19th.
10th?
19th.
Oh, 19th. Let me take a real close look because I know that we have planned, let me look real carefully.
Is that 1 o'clock on the 19th, Your Honor?
It is.
That date and time would work for my schedule.
Thank you for being patient with me, Your Honor. March the 11th, March the 19th. March the 19th is a Wednesday, Your Honor. Will you always be doing these on Wednesdays?
Occasionally we have some Mondays.
The only reason I ask is because Wednesday is motion day here in Oakland County, but I'll do whatever you require me to do.
All right. Yeah, I don't have another Monday till later. So if you're available the 19th, we'll set that. This should give you plenty of time to make sure it's blocked off for other matters. We start that hearing at 1 p.m. That is a in-person hearing. It does look like the child, so I typically start interviewing kids at age 7. And it looks like by March 19th, the child will be 7. So there would be a child interview prior to the hearing at 12:45.
And thank you, Your Honor. And so did you say 1 p.m. on the 19th?
Yes.
Okay. Okay. Wish everybody a Merry Christmas and thank you for hearing us.
Thank you. We will send out a notice. Thank you both for appearing. You are all set and can sign off.
Thank you, Your Honor.
Your Honor.
The council could please place their appearances on the record.
Good morning, Your Honor. Elliot Blumberg on behalf of the plaintiff who is appearing via Zoom from my office.
Good morning, Cassandra Suter on behalf of defendant Brian Odrin, who is here via Zoom today.
Thank you. This is an initial hearing to address custody, parenting time, and support. Mr. Blumberg, as plaintiff's counsel, what would you like to say regarding those issues?
Well, Judge, my client and the children reside in Otsego County. They attend school in Gaylord. The defendant resides in Lake City. So it's not clear to me whether custody is at issue. It appears that it is. If that's the case, then we would ask the court to set an evidentiary hearing as soon as possible.
Ms. Suter, what would you like to say?
We have a mediation date set for February 13th with Jerry Shefflow. We also, currently the parenting time is being exercised to my knowledge without issue. I think that those issues can be resolved in mediation, but I'm happy to also set a evidentiary hearing date if it's after the mediation on February 13th.
All right, I don't like to fill up spots if we're not going to need them. Do you have any level of confidence as to whether or not you'll reach an agreement on custody?
Again, Judge, my understanding, and I don't think I'm misspeaking the situation, the defendant lives in Lake City. He works basically out of the Detroit area. The parties have been exercising without an order, basically every other weekend parenting time schedule. If that became the agreement of the parties, we wouldn't need an evidentiary hearing.
That would not be something that my client would want to be agreed to right now. I think it's a temporary schedule that is working, and also he recently obtained a new position that is in the area, so he's no longer in the Detroit area. I think every other weekend is working right now, but my client would like more time, especially with the son, I think we need an evidentiary hearing date because I believe the son would like to attend school with father. So, I mean, I don't know if we'll agree on that. We might have a better better idea with the daughter because she's 16 now. That's a little bit easier to deal with.
And you said mediation is mid-February, is that correct?
Yes, it is February 13th.
Judge, I just don't want to waste time, not have a hearing scheduled. When mediation proves to be unsuccessful, then we're looking at the spring before we can have an evidentiary hearing.
Well, I'm going to give you a date that I can still, because you can let us know right after whether or not it's successful, and then we would have a chance to fill the space. So I'm looking at Monday, April 14th. We have 9 o'clock available or 1 o'clock.
April 18th?
14th.
I'm not quite as old as the last guy, but I think my hearing is probably not that great either.
It is fading, Mr. Blumberg.
Regardless of age, mine is strangely good. I'm April 14th. I'm fine anytime.
As am I.
All right. You guys want the 9 o'clock then or the 1?
Yeah, 9 o'clock's fine.
Is it in person?
It is.
I would prefer 1 p.m. just because I am not located in Traverse City. I am much further away. If that's okay.
Where are you?
We'll set it then. We'll set it for 1 p.m. on the 14th. And there would be interviews, child preference interviews at 12:45.
Okay, great.
I would just ask that, when you have the mediation, if you could just let us know if, there is an agreement so that we can get that date filled with another case.
So,
We will do that.
if I need to get a hold of you, where do I look? Where are you working from?
It's complicated. I used to live in Michigan. I grew up in Canada. I'm currently in Canada, but trying to come back to Michigan. The house market's not great. So I was in the Royal Oak area, short story.
Okay. I was in Huntington Woods, so I know the area all too well.
Oh, very close. I used to run through Huntington Woods when I did a half marathon.
I've got a docket to run here.
I thought I recognized you. Thank you, Judge.
Thank you. Thank you for being here. We'll send out that notice for that hearing on the 14th at 1 p.m. Thank you.
Thank you so much.
We have the parties on that matter present. Are present, you need to unmute, please.
Present.
Present.
All right, so we do have everybody here. This is the initial hearing regarding a complaint for divorce. Ms. Webb, you are the plaintiff, so I will ask you first, do the two of you have any agreements as far as custody and parenting time?
Yeah, I think we're pretty much in agreement about everything.
Okay. So what is the agreement as far as custody and parenting time?
I think it's already established through friend of the court, actually.
Is that
in the 2018 case? It could have been before it was dismissed.
all right? So it sounds like you filed previously for a divorce. That case got dismissed, but there were some orders that went into place before it got dismissed as far as our agreements. Is that correct?
Yep. Yes, sir.
So you want to continue to follow that prior terms in that case?
I mean, that works for me. If that works for you.
Yeah, that works for me.
All right, let me see if I can pull that up. Well, so what kind of parenting time is being exercised?
We're kind of just working together at this point because he lives down in Alabama.
All right, so maybe we should readdress it a little bit then. The last order for parent time that I see discusses meeting at Burger King and South End Burger King.
That was a long time.
So it'd be parent time if you as the parties agree, which we can certainly continue to do that. All right, so we have joint legal custody and primary physical to mom and parenting time as the parties agree. Is that correct?
Yeah,
Correct.
Yes.
And it looks like when support was calculated, it was based on 10 overnights. Are you asking that it remain at that number of overnights?
Yes, let's leave that intact. Are you cool with that, Nikki?
Yeah.
All right, let's do this then. Ms. Webb, I'll start with you. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And is it correct that you're asking the court to issue an order that grants the parties joint legal custody of the children and you the primary physical custody?
Yes.
And parenting time would be as the parties agree, and the support calculation would be based on 10 overnights. Is that correct?
Yes.
And do you feel that is in the best interest of the children?
Yes.
Okay. Mr. Webb, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Sir, are you also asking the court to enter an order that would grant two of you joint legal custody and Ms. Webb would have the primary physical custody?
Yes.
And parenting time would be as the parties agree, and a support order based on 10 overnights would be issued?
Yes.
And do you believe that's in the best interest of the children?
Yes.
Friend of the court, do you think there's any other terms that we need to address?
I do. Since the 2018 divorce action was dismissed, we were just asked that the accounting from that case be transferred to this new divorce action, and that all balances in charging commence effective January 1st on this case.
Okay, so I would order that as part of this case. And I assume friend of the court's going to want updated financial information. Did the two of you receive that packet of information to fill out with your financial information yet?
Yes, I think I did.
All right. Have you returned it?
No, not quite.
Let me make sure I got it really quick. 1 second.
I would ask, man, that you get that submitted within 21 days.
Okay. Yes. I'm not good at this.
Is it this blue packet right here?
Yes, sir.
Okay.
So if you can fill that out and get it back within 21 days. Sir, do you mind just confirming your mailing address?
It is 12 Thicket.
Okay. All right, so we are going to enter that order, indicate that both of you need to return your financial information within 21 days, and a new support recommendation will be prepared. Any questions?
No, sir.
All right, Mr. Webb, any questions?
No, sir.
All right, thank you both for appearing. You are all set and can sign off.
Thank you. Have a great day. Merry Christmas. Bye.